Welcome, everybody. I can barely see you. I hope you're seated. I'm Rick Newman. I'm the director of the American Museum of Tort Law, and it's really a pleasure to welcome you all here tonight to this, which is our third Leaders in Law program, which is an opportunity for people here and on our website to hear from lawyers who have been doing just remarkable work. And obviously tonight we have one such lawyer. Before I go further, I have to check my notes because I want to get this right. I want to welcome the members of the Fire and Emergency Medical Services who are with us tonight from Canton, East Hartland, Harwinton, Litchfield, New Hartford, Norfolk, North Canaan, Torrington, West Hartford, and Winstead, and Lakeville. And anyone who I've overlooked, thank you as well. I want to thank you all for being here. I think this is going to be a remarkable program. Our speaker tonight is John Barylick. He is a graduate from the Boston University School of Law and a litigator since 1977. He founded his own firm in 1982. His practice has primarily been representing injured plaintiffs in civil litigation, medical malpractice cases, wrongful death, and catastrophic injury litigation, which was good preparation for his involvement in what has been horribly termed America's deadliest rock concert, which was the Station Nightclub fire in 2003. From 2003 till 2010, John was one of the lead attorneys representing the many, many people who died there and their families, and the victims of that fire. Killed 100 people. He ultimately recovered a verdict settlement of $176 million. Sounds like a lot of money until you think of 100 people dead and hundreds injured. He's the author of the book Killer Show. John was kind enough to bring and sign that book. It is a remarkable book. It will give you chills. I encourage you to pick it up on your way out. It's just well worth reading. Tonight, John is going to be doing a multimedia reconstruction of the fire and its aftermath in his master class here. I'm going to, unfortunately, interrupt him in about a little over an hour to leave time for questions and answers, and I'll be wandering around with a microphone. Raise your hand. I'll try to see through the glare of the lights to find you. If you have a question, raise your hand. I'll get to you. Please stand up because we are filming this. We want to make this available to lawyers, groups around the country, any groups that are interested around the country. So work with me on that. And then afterwards, we'll be out there for a few minutes if you'd like a chance to say hello to John. And with that, it is really my great honor to welcome one of the remarkable lawyers of our time, John Barylick.
Thank you, Rick. Thank you so much, Rick. It's a pleasure to be here at the museum. Pleasure to have so many people from the fire service here. Really appreciate it. If you're from New England, if you're from this area, and especially if you're in the fire service, you probably remember where you were almost 16 years ago when you turned on the 11 o'clock news and you saw the horrible video from West Warwick, Rhode Island. You heard that an over-the-hill heavy metal rock band from California, Great White, had set off illegal pyrotechnics in a non-sprinklered, rundown roadhouse in West Warwick, Rhode Island. Sparks from that pyro struck egg crate polyurethane foam, which had been glued to the walls in a ham-handed attempt at soundproofing. It immediately caught fire. People headed to the exits, but within about 90 seconds, there was a pileup in the front doorway where the ramp in sloped downward slightly, so it was kind of likely that someone would fall. And people tripped, people tried to climb over, people tried to throw themselves over. And as I say, within 90 seconds of ignition, it was piled up from floor to ceiling, thereby depriving most people of the one egress that they knew, the door they came in by. The horrible result, as Rick mentioned, was 100 deaths and over 200 people injured, several of them catastrophically. You might ask yourself, as you probably have, this is the new millennium. We've got sprinklers, we've got codes. We know the hazards of structure fires. How could something like this happen in the new millennium? Because we all assume it can't happen in our hometowns. And the answer is that negligence and greed overcame any concerns for safety. And there was enough blame to go around. Now, if you want to figure out how this tragedy happened, I think it's best to understand the building. So let's take a look at the building and see how this could come about. The Station Nightclub, through its various life incarnations, was a restaurant, a sports bar, some kind of rundown bar, until in its final incarnation, it was a rock club with alleged capacity for hundreds of people. It hosted local bands during the week. Maybe once a month they would have a national act such as Great White. Really doesn't look like much of a club or a building. As you can see, it had a main entrance with double doors, crash bar equipped, handicapped ramp, stairs going up. To the left of the double doors, windows for the main bar area. To the right, curved plexiglass windows in an area that they called the atrium. That area had 3 breakable glass panels. You can actually see 2 of them dimly in the slide and a third around the corner. Those were the only breakable panels. At the time of the fire, 2 of them were broken out. Unfortunately, this clear plexiglass led a lot of people to their deaths because they thought that they could break it and that there would be egress that way. To the right of the atrium was the band door, through which bands loaded in and out. And that door had a story of its own. Because it was very near a residential area, right to the right. And of course, those residents always complained about the loud noise, the thumping bass. So in order to mollify those residents, the owners of the nightclub, the Derderian brothers, bought egg crate polyurethane foam, interestingly, from the nearest neighbor, who was a salesman for the foam company. They figured they'll kill 2 birds with 1 stone. They'll give them a little money, and they'll put this stuff up. Maybe it'll do some good. Except this was non-fire retardant packing grade foam, and they covered the entire west end of the club with 900 square feet of it. Also, the band door had its own set of rules. And again, with concern for sound, they were very simple, and this is what the bouncers were told. They were told, you can't open that door when music is being played, and the only people who can use that door have to be with the band. Now, those are very simple rules, and they're probably good rules for noise abatement until there's a fire. But there was very strong evidence that during the fire, more than one bouncer turned multiple people away from that door because they were not with the band. And this was after the fire was actually appreciated to be underway. Let's look at the floor plan so we can get an idea of what exits were available to people. Here's the floor plan of the club, and let me highlight the exits available. Here's the main entrance, the double doors with a single swinging door within the entry foyer. This is the downward sloping entry hallway. And at the entrance, a 33-inch pinch point between the ticket desk and the corner of the wall. Great for keeping people out who hadn't paid, not so good for getting people out in the event of a fire. The other available exit was an exit off the main bar area, lit with an exit sign, crash bar equipped, but as far from the performing space, that is the stage, the dance floor, and the drummer's alcove, as you could get. In order to get from that dance floor area, you had to work your way around the horseshoe bar and out that exit. And you also had to know that the exit was there. Another exit was off of the kitchen, extremely poorly marked, essentially known only to the staff, and the only people who got out through that door were staff members. And finally, the band door that I mentioned before. Now, if you look at this picture closely, I'm not sure you can see on the projection, but it's actually a double door, one that swings outward and a second one that was installed to swing inward, again, concerned with noise. Now, those of you who are involved with code enforcement know that inward swinging egress door is a code violation. I mention it here not because it impeded egress on the night of the fire. We'll see some photos and some video showing that from the moment of ignition, both of those doors remained open. Okay? But as an example of how this establishment treated the fire code, and that is, for 3 years running, that inward swinging door was cited as a code violation. And for 3 years running, the owner would take the door off the hinges, have the inspector come back, check off complied, and rehang the door. Now, you would think that by year 2 or 3, people would get the idea that the fire code was not being treated very seriously here. Okay? Apparently not. Apparently not. And interestingly, the foam that covered the entire west end of the club and the ceiling over half the dance floor was glued on top of that inward swinging door. The door was cited 3 years running for opening inward. The foam was never cited. You had to literally reach through a hole in the foam on the door to pull it inward. And yet it wasn't cited. So those are the 4 available exits. Technically sufficient under the code. They were wide enough, they were numerous enough, but they're not very helpful if the main one is foreclosed due to a pileup. Bouncers turn you away from the stage door because you're not with the band, or it's unknown to you or distant. You can see the other areas of the club: the main bar, kitchen, dart room, storeroom, office, men's room, ladies' room. You would think there would be some exit window or doors from this quadrant of the club. And indeed there had been. There had been windows from the office area, but those were long since barred over. And there had been an exterior door at one time. We found concrete stairway outside, but that was long since walled over. So those were the available exits and the main areas, but this is where most people were. In the dance floor, here's the stage where Great White set up, and the drummer's alcove where their drummer sat. And on the floor between the drummer's alcove and the stage was set up pyrotechnic gerbs. Think industrial strength sparklers. These were, if you've ever had a model rocket engine when you were a kid, think much bigger. And these were rated 15-15. That is, they threw a 15-foot plume of sparks, and they had a 15-second burn duration. And Great White set 2 of them up straight up and 2 of them at an angle. Unfortunately, the 2 at an angle struck the polyurethane foam at each corner of the drummer's alcove, which immediately burst into flame. I'm going to give you a 1.5-minute immersion into what it was like inside the club when the pyrotechnics went off. This was shot by a cameraman for a local TV station. You may say, well, why was there a cameraman from the TV station inside the club that night? And the reason is one of the club owners, Jeffrey Derderian, had a day job, and that was as a TV reporter. 3 nights before, there had been a tragedy in a nightclub in Chicago, and he thought it would be great to do a story on, of all things, nightclub safety. So he had a cameraman from his station inside the club for the Great White concert. And what you're going to see is a 1.5-minute clip of the Brian Butler shot video. As Great White comes on, the pyrotechnics are set off. You will see the sparks immediately catch on the foam. You will see that the cameraman appreciates his peril and starts to make his way out. And you will see how the mood in the club changes from party to curiosity to concern to horror within about a 20-second period. I will stop the video after about a 1.5 minutes before it gets too upsetting. See the sparks hitting the foam and already flame on the foam. Most of the band is not aware of what's happening behind them. Cameraman does. Cameraman starts to make his exit. You can see the band door open with the light outside.
Wow. That's not good.
Get the fuck out of here! Joe, take a picture.
The cameraman moves through the pinch point that you saw on the floor plan. You'll see a policeman here who was on a detail that night within the club. That's him. He called in the alarm to the fire station a half mile down the street.
Oh my God!
Cameraman makes his exit and then walks between the parked band bus and the atrium windows back to the band door. There's the band outside. The building's already heavily involved. Turns around. The first broken panel is broken out of the atrium windows. That fella was the first to tumble out. Look at the byproducts being pumped out of there. And makes his way back to the front door. And there's that horrible pileup at the front door. Even if you had your head and shoulders and arms extended from the pileup, there was very little chance that you were going to be extracted from that pile. Many people tried, okay? But the people had tipped like dominoes, so they were wedged diagonally and kind of locked into that space and remained locked in until they were overcome by the smoke and flames as it progressed through. It was a horrific situation. Again, 90 seconds from ignition to pileup. I mention this because a lot of people get defensive when you hear about this tragedy and they say, you know, these people, maybe they were drunk or they weren't paying attention, but I would have been smarter and stronger and faster. I would have gotten out. And when you see this and you see the timing, you realize that whether you got out or not that night depended on one thing, and that is luck of location. Nothing more. Doesn't matter how big or fast or sober or strong you were. That's all it depended on. A 100 people died, as I mentioned. 96 right on site, 4 in the days and weeks thereafter. Okay, this was unprecedented tragedy for the small state of Rhode Island. So it was pretty inevitable that there'd be a call for heads to roll and criminal prosecutions. The criminal prosecutions were unfortunately limited to 3 people. 3 people were indicted. Dan Beakley, who was the road manager for Great White. He was the fellow who physically connected up the pyro. And the club owners, Jeff and Mike Derderian. These are the people who put the foam up on the walls, who overcrowded the club, and who tolerated, if not encouraged, illegal pyrotechnics by bands at the club. Dan Beakley ended up serving 16 months after pleading guilty to 100 counts of manslaughter. Mike Derderian served 27 months after pleading no contest to 100 counts of manslaughter. And his brother Jeff Derderian, as part of that plea deal, served 0 jail time. Some people are conspicuously absent from these criminal indictments. One being Jack Russell, who was the lead singer you saw for Great White. This was Jack Russell's Great White, if you will. He and Mark Kendall, 2 original members of the band, with 3 session musicians along. Okay. Jack Russell ran this tour. He made every decision. He decided where they'd go, what they'd play, what they'd eat, and whether there would be pyro or not. And yet, for some reason, he was never indicted criminally. Similarly, the fire inspector, Dennis LaRoque, the fire marshal for the town of West Warwick, who, as we'll see in a few minutes, allowed absurd overcrowding of this venue and overlooked the flammable foam for 3 years running. No criminal charges. No indictment. Here. So people were To say dissatisfied is a vast understatement. Many people said, oh, this is the Rhode Island shuffle. They knew a guy, etc. And there was great pressure on civil litigators like myself and the other members of the plaintiff steering committee to try to bring about a result that would shed some light on what happened here and bring a more substantial feeling of complete justice to the community. Except we had a strategic problem for the civil cases, and that was that the most clearly culpable defendants, specifically the band and the club owners and even the town of West Warwick, had no substantial assets. The band had $1 million liability policy. The club owners had $1 million liability policy. But that doesn't go very far when you have 100 deaths and 200 injuries. They were, as we waggishly say in the plaintiff's bar, judgment proof. In other words, it doesn't matter if you get a $500 million judgment against the band or the Dudarian brothers who owned the club, you'll never collect it. So, as plaintiffs' tort lawyers, we were pressed into doing something that, if you believe in the tort system and the civil justice system and its importance in driving good behaviors, you find fine. If you're on the other side of the bar, you might find anathema. But that is, we had to develop theories of liability against much less obviously culpable defendants who were somewhat at fault, but much more able to respond to a judgment. And when I say somewhat more at fault, in Rhode Island, as in most states, we have a form of joint liability called joint and several liability, which is just fancy words for saying that more than one person can be responsible for a single injury or group of injuries. Now, you might sue 5 people who might be 30% responsible, 20% responsible, 5% responsible, and you can sue all of them. And if you win against them, you can collect your judgment against any one or more of them, regardless of their percentage of fault, but they have a right over against the other faulty people to make themselves whole by the percentages, if you follow me. Now, what that does, as a matter of public policy, is shift the risk that a particular defendant might be judgment-proof from faultless plaintiffs to defendants who are at least somewhat at fault. Okay? So using this system of joint and several liability, we had to press more novel theories of liability against these defendants. For example, product liability theory, defective product by virtue of defective warnings against the most likely manufacturer of the polyurethane foam that was on the walls. We had some difficulties because these were a generic product, unlabeled, okay, bought through a middleman, but we were able to get discovery of what manufacturers shipped to that middleman and which manufacturers most likely produced the foam without any flammability warnings that ended up on the walls of the club. The promoters of this concert. Now, normally promoters of an event are not liable for anything bad that happens. But if it can be shown that a promoter sufficiently controlled the details of the performance, so they should have known about the pyro being set up and stopped the show, then they can be. And in this case, we had promoters, a local radio station, a local beer distributor, people who contributed to the advertising and the promotion, and even provided the MC for the show. A fellow named Mike Gonsalves, a.k.a. Dr. Metal, a radio station disc jockey who lost his life in the fire. Okay, but he was provided by promoters. And we were able to allege and make a showing that he sufficiently controlled the stage while they were setting up the pyro to make his employer, for whom he was an agent, liable under a theory of what's called respondeat superior. That is, the master is responsible for the negligence of his servants. So we were able to sue the radio station and some of the promoters that way. The fireworks manufacturer and seller. Now, you may say, fireworks, wait a minute. These were 15-15 gerbs. They burned for 15 seconds. They threw a plume of 15 feet. What are you suing them for? The product worked just the way they said it would work. Except this federally licensed manufacturer of fireworks out of Alabama, by federal law, can only sell to licensed pyrotechnicians. Well, they weren't too bothered with that. If they wanted to sell to somebody like Dan Beakley, the road manager for Great White, who was not a licensed pyrotechnician, they would just fill in the number of a licensed pyrotechnician on the federal data sheet. We came to find that out. We were able to settle with that manufacturer for their insurance policy limit, and indeed, shortly thereafter, they lost their federal license to produce fireworks and went out of business. Insurance inspectors. Now, this is kind of logical. For 3 years, and really, 3 years running, the companies that provided fire insurance on the building would inspect the building through agents. They would pay an inspection company to inspect the building before they would underwrite that fire risk. And for 3 years running, they overlooked the flammable foam on the walls. Now, we know what they paid for these inspections, and they got their money's worth. Each year they paid $45 for these inspections. So it probably consisted of a drive-by to say, yes, there's a building there. Okay? But interestingly, as negligent as those inspections were, and they were grievously negligent, in tort law and in negligence, there's a threshold issue before you can recover anything. And that is to establish that however negligent the defendant was, they owed a legal duty to the injured person. And in the case of the insurance inspectors, the courts in 49 out of the 50 states have held, and they did in our case, that the inspectors only owed a legal duty of care to the insurance company. They weren't doing these inspections to protect the public. They were doing it to help the insurance company make its underwriting decision. And therefore, no matter how negligent they were, you, injured public, can't recover against them. So our claim was thrown out against them on that threshold issue of duty. We sued Brian Butler, the TV cameraman, and his employer, Channel 12. You say, wait, the cameraman? Are you kidding me? He didn't set off the pyro. He didn't overcrowd the club. You plaintiffs' lawyers, you're taking this too far. Except there was credible evidence from several people who just barely made it out that while they were trying to make their escape, they were delayed and could not get around this guy that was standing in the hallway with a camera on his shoulder, holding his ground to get the shot. Brian Butler, for his part, denied it vehemently, but we were able to develop evidence showing that it was quite likely that for a critical 13 seconds, he held his ground in the doorway. Now, you may say, 13 seconds, it didn't result in all the deaths, and you're absolutely right. But when we showed the insurers and lawyers for the TV station the reconstruction that showed where he stood at what points in time and showed the screenshots from his film, they were among the first defendants to contribute to the global settlement. I mentioned PE foam manufacturers. We found out a year and a half after the fire that that polyurethane foam was not the only foam plastic involved. It turns out that in 1996, a prior owner of the club, one Howard Julian, put polyethylene closed-cell foam blocks, 17 inches by 17 inches, and screwed them into the walls of the drummer's alcove. And then the Derderian brothers, when they bought the club, took the polyurethane foam and glued it on top. Okay? We discovered this second type of foam and believed that it contributed substantially to the speed and the lethality of this fire. And I'm going to show you, if we have time this evening, how we developed that proof. And finally, the beer company, Anheuser-Busch. You say, the beer company, come on, guys, you plaintiffs' lawyers. You're making everything more expensive for us, even my beer. The beer company didn't overcrowd the place. They didn't set off pyro. What's the possible theory there? But it's not quite that simple. Anheuser-Busch had a promotion, you may remember if you're old enough, at the time of what they called born-on dated beer. Okay? That was, they were bragging, we have the freshest beer. And they arranged as part of a promotion that night to have Anheuser-Busch reps on site, and they brought down a truckload of beer from Merrimack, New Hampshire, from their bottling plant that was born-on dated that day. And the reps would go around and they'd pull a long neck from their stash and give it away to people and extol the virtues of fresh beer. I'm sure it tasted vastly different from any of the other beer there. Okay? And they provided big posters, signs for this concert that said, "Party with Budweiser and Great White," lending the Anheuser-Busch good name and Budweiser's good name to this concert. And you say, okay, big deal. You had this promotion, you sent reps, you promoted it. You fire professionals are aware of what the NFPA is, okay? NFPA, National Fire Protection Association, is the national organization that has subcommittees on any subject you can imagine, okay? And they promulgate standards for anything you can imagine. One of their subcommittees is a committee on the safe use of pyrotechnics before proximate audiences. Sounds apt. And we came to learn that at the time Great White was doing this, two of the members of the NFPA subcommittee on use of pyro were high-level executives of Anheuser-Busch. And if they had looked at what Great White was doing on this tour over the country, that is setting off illegal pyro in every venue they could, and violating every standard promulgated by that NFPA committee on which their executives sat, a reasonable person would not have been promoting that appearance. Now, you may say, why does a beer company care about pyro? And the answer is Busch Gardens. At the time, they owned the theme parks. Second largest consumer of pyro after Disney Company. Okay, so they were very concerned about setting standards. They just weren't too concerned about this band that they were promoting and that they were violating those standards. So we had to press claims against much more peripheral defendants in order to put together a global settlement fund because the most heavily culpable people just had nothing. Let's talk about one of the people we sued and his employer who we sued, and that was the fire marshal, Dennis LaRocque. In Rhode Island, like many other states, the fire marshal is provided by each local community. And in Rhode Island, not only is the fire marshal a local firefighter, but he is a deputy state fire marshal. So he has two masters. If he's negligent, the community is responsible and the state is responsible. So what were the theories against Dennis LaRocque and his employers? Well, first, that he increased the legal occupancy beyond law and reason. We'll talk about that. And that he overlooked that 900 square feet of egg crate foam on the walls during 3 years of inspections, two of which, by the way, were conducted personally by him. Let's talk about increasing the occupancy. This is a floor plan, again, with scale markings, these blue blobs on here, that are in scale the width of someone's shoulders. It illustrates what the permitted occupancy was at the Station Nightclub on December 29th, 1999, when that previous owner, Howard Julian, owned the club. It was 253. Now bear in mind, this is theoretically the maximum under the state fire code. But Howard Julian was trying to sell the club, and he knew that the higher the rated occupancy, the more likely he'd be to get a fair price. So he met with the fire marshal and he said, is there any way you can increase the occupancy? And Dennis LaRocque, the fire marshal, said, you know what? On this raised platform, there are some tables, chairs, and in the main bar area, there are some stand-up tables and chairs. When you have a concert, take those out. I will call these areas standing room, for which you only have to attribute a small number of square feet per occupant, 5 under the code. And bingo, with the stroke of the pen, the next day, the capacity is 317. And see what the density would look like walking into this club, dark, smoky, loud, ceilings about this height for everywhere but the dance floor. Okay, and this is the density of humanity that you walk into there at 317. Bearing in mind, when this was a restaurant, same building, same size, with a capacity of 50, and we're now moving up through the 200s and the 300s, is that a change of use or occupancy that would stop the grandfathering of the no sprinklers? Sure looks like it. Okay? No one seemed to raise that. No one seemed to raise that. So the next day, it's 317. Fast forward 2 months, the Dudarians buy the club. Michael Dudarian meets with Dennis LaRoque, the fire marshal, and says, you know, is there any way you can get the capacity of the club over 400? Because, you know, we like to tell bands that it's got a higher capacity. They get a piece of the gate at a certain point. And LaRoque said, well, you know what? If on the nights of the concert you take every stick of furniture out of the club, we'll call the whole building standing room and attribute 5 square feet per occupancy, and bingo. March 21st, 2000, it's 404. This is what the density would look like walking into that space with a capacity of 404. But you know, it wouldn't really look like that because there aren't sight lines from down here. It would look more like this. And I show this to people, if for no other reason, to address those who say, you know, I'm smarter, I'm bigger, I'm stronger, I would have gotten out. And when you see this, you have to imagine that you're in the middle of that group looking at the stage, and you're among the first to realize that fire is not part of the show. So you want to get out. You're at the mercy of the person behind you, in front of you, to either side of you. Let's say the crowd starts moving toward the front door, and because of that pileup, it stops. You know of another exit. You're smarter, you're faster. You can't go. You're still at the mercy of those to either side of you. So again, luck of location and nothing more. But you know what? It didn't look like that night, because through reconstruction, we've been able to establish that there were actually 460 souls in the club that night. Because the Dudarians didn't care about occupancy limits. If they ran out of tickets, they would take money and give you a business card and write admit 4 or a piece of notebook paper or something. Just give us the cash. So that's the overcrowding. Let's talk about the foam on the walls. Here's a picture of the club, the drummer's alcove, at a gig before the fire. And as you can see, the presence of the polyurethane foam was not exactly a subtle finding for the fire marshal. These are 4-foot by 8-foot sheets of flammable packing foam hung on the walls. But no, he testified before the grand jury, he just didn't notice it. Just didn't notice it 3 years running. Now, Rhode Island, like every state, in its fire code, has a prohibition of flammable, acoustical, or decorative material. Every code has this, okay, particularly after the Coconut Grove fire in Boston. It says they've got to be flame resistant. And you know, if there's any doubt as to whether it's flame resistant or not, the code itself provides a test, the match flame test, very simple test that the fire marshal can use to determine whether it passes or not. You take a simple wooden kitchen match and you hold it to a specimen that's 1.5 inches wide and 4 inches long, and you hold it to the bottom for 12 seconds. If the flame moves more than 4 inches up the sample in 12 seconds, it fails. If there's more than 2 seconds of after flaming after you take the match away, it fails. If it drips any flaming particles it fails. Now, Mr. LaRoque did not do any match flame test or any other test on this foam. But let's see what would have happened if he had done the match flame test. This is a sample, 1.5 inches wide, 4 inches long. Now, I didn't hold the match there for 12 seconds. I didn't have to. Gee, did it go more than 4 inches in 12 seconds? Absolutely. Was there more than 2 seconds of after flaming after I took the match away? Absolutely. Did it drip any flaming particles? Well, you got a puddle of napalm here. And you look at this and imagine 900 square feet of this stuff covering the west end of the club and angled over half of the dance floor, raining this kind of napalm on the poor patrons. But no, LaRoque didn't do any such test. So, he allowed overcrowding that was beyond common sense. And by the way, to call an entire building standing room, the fire code prescribes what standing room is permissible. That is, quote, an area immediately adjacent to an exit. Okay? Never before and ever since has an entire building been categorized as standing room for occupancy purposes. Okay, so it was illegal and it didn't make common sense. And here you allowed over 3 years running the polyurethane foam to cover the west end of the club. Slam dunk, right? Outrageous. Except we had a little problem in Rhode Island. And that is we have a statute that provides for immunity of the fire marshal. It says any fire marshal acting in good faith and without malice shall be free from liability by reason of any act or omission in the performance of his or her official duties. Wow. You know, I wasn't privy to the prosecutorial discretion decision not to seek an indictment of LaRoque, but I can't help but imagine that this statute played a large part. I mean, no elected attorney general wants to indict someone and have it thrown out on a technicality. But we as civil attorneys look at this and say, you know, good faith, as in good faith in performance of a contract, has a little different meaning in a civil sense. And that is, we don't regard as allowing 900 square feet of solid gasoline to remain on the walls and calling an entire building standing room as good faith performance of your duties. So we sued LaRoque, we sued the town, and we sued the state. And I made a very similar presentation to this before the town council for the town of West Warwick. And before the presentation, I got to tell you, the body language of the town council was defiant. What do you mean? Our guy did his job, we've been criticized too much, etc. At the end of the presentation, when the lights went up, it was a whole different story. Whole different story. And eventually, the town of West Warwick settled, contributing $10 million toward the global settlement, and the state, also LaRoque's master, contributed another 10. The town only had $6 million of liability insurance. It floated a bond issue for the remaining 4. So the good people of West Warwick are still paying for the defalcation of their guy, Dennis LaRoque, here. You may ask yourself, by the way, why would you have such a statute? And the answer is it's to encourage people to want to be fire marshals. And it's to work in a different situation, because the only case interpreting this statute in Rhode Island is the type of case it was designed for. That is, the fire marshal vigorously did his job, he shut down someone's business, and under this statute, you can't turn around and sue him because he did his job and he shut down your business. But in this case, it got turned on its head to give alleged immunity to the fire marshal when he didn't do his job at all, or worse. Okay? And I can tell you, the statute still sits on the books in Rhode Island unchanged. Let's talk about what I call mystery fuel. Our fire experts who watched the video that was shot, and by the way, after Brian Butler made his escape from the club, he kept shooting from the outside continuously, never hit stop, never hit pause. And as the firefighting and the rescue efforts and eventually recovery efforts ensued, as our fire experts watched that film, they were impressed because the intensity of the blaze in the initial minutes was beyond what one would expect of a fire fueled only by this polyurethane foam. The reason I say that is polyurethane foam, it's open-celled, it was dry, it catches fire very easily, but it's like flash paper. It yields up all its energy in about a minute. And yet, from the video, you could see energy being pumped into that fire with byproducts of hydrocarbon combustion. You saw the smoke, okay? Absolutely opaque black smoke being pumped out for minute upon minute upon minute after this. So they were puzzled. They suspected some other fuel. Again, there's that thing. What we came to learn is what I described to you before, that back in 1996, when Howard Julian owned the club, he put up polyethylene foam box in the drummer's alcove. Now, here's a shot of a band, the great backstory here. This is a Black Sabbath tribute band, okay? This guy who pretends to be Ozzy Osbourne would appear at the club about 4 times a year, and they'd play the club. And it was through him, by the way, that we were able to get a pristine exemplar of this kind of foam, because back in 1996, he was loading equipment into the club, and he saw a stack of these blocks outside the band door, and he said, hey, I can use those to pad instrument cases or something, and he stole a couple of them. And in 2003, when he's watching the fire, broadcast from a place that he often played, and they're talking about burning foam, he thought, gee, years ago, I took some blocks of foam. We contacted him after the fire, and I said, boy, is there any chance you have any of this stuff? He said, oh, absolutely not. He looked, and he found in the scrap bin of his dad's shop one piece of this stuff that gave us an invaluable pre-fire exemplar that we could cut up and test. This is actually what's left of the piece. We cut up about that much off and tested it to try to figure out its provenance. Okay, so you can see here in this shot, here's a picture of the would-be Ozzy Osbourne with the polyurethane foam glued on top of the polyethylene blocks. Now, the blocks were spray painted black, but kind of dinged up on the edges. So what you've got there is really a sandwich, like that. And that's what we had in the drummer's alcove. And we had to scramble to find out where Howard Julian got this stuff so he could identify a manufacturer and see if it was labeled for not using it as a building material or flammability, anything like that. We were able to narrow who made it. But we would really have an uphill battle there, because the plaintiffs would have to prove, first of all, who made it and sold it. Howard Julian wasn't forthcoming about that. Was its acquisition foreseeable? Was its use as a sound insulation in any way foreseeable? This looks kind of like packing foam. Was its misuse in a place of public assembly even foreseeable? Was it dangerously defective in its warnings? Was it possible to even put warnings on this stuff? And most importantly, did it make a difference in this fire? Because it doesn't matter how defective or poorly labeled something was. If factually it didn't make a difference in the outcome here, there's no claim. So let's see how we address some of these questions. First, in trying to find out where it was acquired, I took the deposition of Howard Julian, and Howard Julian. And he could remember all manner of things about his business. And he had records about all things of his business, but he just couldn't remember where he got that foam. Why would he be so disinclined to identify? Well, remember, at that point, the Darien brothers were in criminal trouble for putting stuff on their walls that was sold to him as sound foam. Okay? So he was of no help, Howard Julian. But we were able to establish data on market share of the different manufacturers that were making products similar to this during the period 1995 and 1996. And we were able to establish that two companies, Sealed Air Corporation and Sentinel Corporation, had the lion's share of the business. We also initially sued AVI, and in discovery came to learn to an absolute certainty that they were incapable of producing a product of that quality at that time. So we let them out. But they gave us their market share results, their market share data, and it helped us narrow it down to the other two. Now, Sentinel was a marginal company, but Sealed Air, they're big. That's the company that makes that bubble wrap that you like to pop when it comes, okay? And we dearly wanted the most likely person to be Sealed Air. And we looked at that market share data, and after you eliminated AVI, which is incapable of producing it, in 1995, Sealed Air had 55% of the market share. In 1996, it had 51%. So in reliance upon that, we took the position that it's more likely than not that this stuff that we're able to find remnants of burned in the walls of the drummer's alcove was produced by Sealed Air Corporation. Okay? But where did Howard Julian get it? He sure wasn't telling me. He said, oh, maybe it was a sound catalog or an insulation company. We took depositions of something like 60 sellers of insulation in the area to see if they had anything similar to this stuff, particularly with the unique die cut on each corner that the blocks had. Came up dry. And then we took the deposition of the club manager from 1996. And he said, well, Mr. Julian told me at that time he did not purchase this foam, but that he found it in a dumpster and that he took it because he thought it would be useful as a sound insulator. Well, there's our answer. That's where Howard Julian got the foam. I can see why he wasn't anxious to tell us, because as I mentioned, the Duderians are in criminal trouble for putting stuff up that was sold to them by a legitimate foam company. But we had something called a privity problem. There's a case that's described in one of the panels out here that is very interesting. It's called Mcpherson versus Buick. And it discusses the development of a requirement in tort law that if you're injured by a product, in the very beginning, you had to be in contractual privity with the manufacturer. You had to be the one who bought it. Now, that doctrine has evolved over the years to reach anyone who is foreseeably within the zone of being injured by that product. But it is a long way, ladies and gentlemen, from contractual privity to dumpster liability. Okay? It's the other end of the spectrum. So we would have to show that Howard Julian's recycling and reuse of that foam was foreseeable. Okay? But we got a little lucky here, because in part of the motion practice, Sealed Air Corporation submitted to the court marketing brochures from 1994 and 1995 for this product. And we read those brochures very carefully and came to discover a few things. Here's a brochure. Oh, reusability. Our products are designed for maximum reuse. Sounds like they anticipated reuse, recycling. Can be reused, returned, and recycled. It can be used over and over again. Recyclable polylam plank. So, from their own literature, they are touting that this stuff is recyclable. So, God knows they anticipated that someone would recycle this stuff. But how about its use as sound insulation? I mean, how foreseeable is that? This looks like packing stuff. Looks like maybe a swimming pool noodle or a kickboard. Well, oh, acoustical insulation. Thank you. Sound deadening. Sound and vibration dampening characteristics. The possibilities are unlimited. The applications illustrated in this brochure are only the tip of the iceberg. By using your own creativity, etc., put it up on your walls. We don't care. Okay? This in their marketing brochures. So we kind of got a gift here in terms of the foreseeability of its recycling and its use for sound. But how about its use in a place of public assembly? I mean, really, isn't that a stretch? Who could possibly anticipate that? So happens that there is another NFPA subcommittee, this one on places of public assembly. And that committee had a meeting, an emergency meeting, a month after the Station Nightclub fire. One of the noted fire experts who appeared at that meeting, actually he sent in a written statement to that meeting, seemed to address the question of, is this foam known to be used in places of public assembly? Surprisingly, okay? Now, we were asked a favor, okay? And when we approached the mediation with Sealed Air, their attorneys asked me, gee, can we bring our fire expert to the mediation? I said, well, either I've got something or I don't. Bring your fire expert, okay? So we go to the mediation, and this is what we saw. We looked at the statement that was given to the NFPA a month after the fire by a noted fire expert. Statement to the special meeting of the Technical Committee on Assembly Occupancies the month after the fire. And that expert says, as evidenced by the recent fire at the Station Nightclub in Rhode Island, the use of exposed foam plastics continues to be a problem. Difficult to assess the magnitude, but I believe it is pervasive. This sounds like the industry knew that it was used in places of public assembly. In my opinion, the unsafe misuse of foam plastics in buildings continues to be a pervasive problem that is perpetuated by improper testing and misrepresentation of the flammability characteristics of these products. Wow. Who is this guy? A shill for the plaintiff's bar? Oops. It's Dr. Maurer, the fire expert they brought to the mediation. Those of you who have any familiarity with mediations know that after we give our presentation, they give their presentation, they separate the sides into two different rooms, and the mediator shuttles between them. They were so annoyed, they left him in our room. I mention here duty to warn of foreseeable misuse because you are probably thinking, you know, this product, whatever it was misused. And as a basic tenet of tort law, you can't misuse a product. You can't go to Sears and buy a Craftsman rotary mower, use it to trim your kid's hair, and complain that something bad happened. Okay? But there are some misuses that are so foreseeable and they are so known by the industry that you do have a duty to warn. And we allege that this was such a situation in light of the literature that we found. Now, you may ask yourself, what type of misuse after disposal are juries even familiar with? Can anybody identify with this? What's an example of a product that gets thrown away after it's used for its intended purpose, and yet we are regularly warned about misuse? Somebody said plastic bag. You go to the dry cleaners. You get your clothes back. On the bag, printed at intervals, caution, this bag is not a toy. Do not use it to line cribs. And it's printed by the bag stock manufacturer, okay, at intervals on the plastic stock. So, foreseeability of misuse after disposal, and something a jury is very familiar with. But we had another big hurdle to clear, and that is, what difference in fact did the polyethylene foam make in this fire? We had to address two questions. How fast was it involved in the fire? Because remember, people didn't, after 90 seconds, you didn't stand much chance of getting out. And how much did it contribute to the fire's intensity? Now, to answer these questions, we engaged a fire testing lab in the state of Washington. And they did what are called corner burn tests. And they built standard corners, one lined with just the polyurethane foam, and the other lined with the polyurethane on the polyethylene sandwich. And these burns were instrumented to see the intensity and the time. Couples were wired through the PE foam to its surface so that we knew when the PE foam got involved. I'm going to show you the side-by-side tests of just the polyurethane foam and the sandwich. And this is what we learned, at least visually, from that testing. The running time is on the right. Polyurethane only is on the left. The sandwich is on the right. Don't pay attention to how fast it spreads. In the initial seconds, it's just polyurethane. Okay? Now, I was struck by the intensity of this when I was there. This is a silent video, but I can tell you the roar from that was almost deafening. The heat flux drove you back 10 or 15 feet. It was absolutely remarkable. And I could only think, what would it have been like to be in that club with this stuff covering an entire west wall and half of the dance floor? Now, during the first minute of the burn, at least visually, the substances seemed to perform identically. But as we approach the 1 minute point, I'd ask you to watch what happens on the polyurethane only side. We're coming up on 52 seconds and now 1 minute. At about the 1 minute point, the polyurethane has yielded up most of its energy. There's some drippings here burning, but for the most part, it is done. The sandwich is going full bore. Now, this dark area here is not that it's not burning. It can't combine with enough oxygen fast enough to visibly flame. When it does, you get these tornado-like vortices as cooler air is drawn in from below, and you get this swirl. It was terrifying. Terrifying. So visually, at least, it looks like the second foam made a difference. But these burns were instrumented. And what we did was compare the heat release rate, which is scientists' shorthand for how severe this burn was taking place, of the polyurethane foam alone and the polyurethane and polyethylene foam sandwich. And the heat release rate difference is striking. The red curve is the heat release rate for just the polyurethane, the light green curve for the sandwich. For those of you who are actually past calculus, the area under the curve is the total energy released. And as you can see, it's almost 5 times that with the sandwich. Smoke production. As most of you might guess, those people who were felled in the fire were usually killed by byproducts. This was toxic stuff. The light blue is the polyurethane only. The darkish purple is the sandwich plotted over time. Again, tremendous difference in smoke production. And finally, the time of involvement of the polyethylene foam, we put thermocouples in at 5 different locations on the corner. And at the 20-second mark, all of them went off, suggesting that the second type of foam was involved in as little as 20 seconds. So arguably, it made a difference in the outcome here. I'm going to show you one other test that was done at the Western Fire Center, and that is they did a standard 10-foot by 10-foot test room and lined it with the sandwich. The scientists there told me that they've been doing room tests for 30 years, and in that time, they had not tested any substance that people were stupid enough to put on walls that was as incendiary as this combination. This is running time from ignition in the far corner here. And its burn is taking place under this hood calorimeter. Okay. It was phenomenal intensity. You're going to see the same phenomenon here where it's burning, but it can't combine with enough oxygen to visibly flame. Okay? Just like video of structure fires where you see high above windows or doors where it combines with enough oxygen to flame. This is unburned hydrocarbon, unburned fuel that's being pumped out of here and combines with enough oxygen to flame. So I show people this, and particularly those who say, oh, I would have been bigger, stronger, faster, etc., and say, you tell me how you would have gotten out of there. Okay? It's very sobering. They knocked this down after about 2 minutes because it was going to overwhelm their facility here. The liability summary as to sealed air then was that sealed air knew of the recycling and the use for sound. The warnings were feasible to print on the board stock. No warnings were furnished whatsoever. The drummer's alcove was the epicenter of the fire. The alcove walls were the sandwich. The PE was involved within 20 seconds, and it made massive contribution to the heat release rate and the smoke. The result of that sealed air mediation was the final $25 million contribution to the Global Settlement Fund, bringing it to $176 million. That total was distributed per a distribution plan that was developed by a special master appointed by the federal court, who developed a point system for compensating the survivors of people who were killed in the fire and people who were injured. As I wrap up, I'm just going to show you where most of the fatalities were by area here. As you might expect, most were in that entry foyer with the pileup, some 31. Another 18 in that blind area heading toward the atrium windows. You know, several in the main bar. Many people headed as far from the fire as possible to the storeroom or the dart room and could not make their escape from there. Very quickly, I'm going to show you some high-res pictures. These were not from the video, but from another cameraman of the ignition sequence. Here's the polyurethane foam. Again, not a subtle finding. The bald guy and the other guy wearing event staff t-shirts are bouncers. This is during the burn. This head you see here is Dan Beakley, the road manager for Great White. He had just ignited those gerbs through the electrical cord that you see on the floor there. You now see the flames on the corners of the polyurethane foam. Dan Beakley is heading off stage to see if he can find a fire extinguisher, belatedly. By the way, here's that band door with the polyurethane foam glued right on it that just wasn't seen by the fire inspector. Here's Dan Beakley back again. No fire extinguisher found, flashlight in his teeth, looking up at the burning foam, much like you looked at those corner tests, thinking, this has a life of its own. We can't put this out. You can see some people exiting through the band door because they were, quote, with the band. Here, the drummer has made his escape from the drummer's alcove. Looking back at the flames, here's Dan Beakley again with his flashlight. Again, other people exiting. A bouncer identified by several people as turning them away from the band door because they were not with the band. With a lit cigarette over the box, the pyro came in labeled danger explosive. And one of the last pictures with Jack Russell throwing a small bottle of water at the column of flame to no effect. This is Tracy King, a bouncer who lost his life in the fire. And finally, the last still picture taken inside the club, which I'm going to leave you with. The reason I put this picture up is because you remember in the video that I showed you, as part of the sound, you heard someone say, "Joe, take a picture." That person was the person with this white sleeve, a fellow named Matthew Pickett. Matthew Pickett's hobby, and the reason why we have that sound, was to make bootleg audio tapes of concerts. And he carried in his jacket pocket that night a Sony digital Walkman, which he had running when Great White came on, and it remained running, and it was found under his body the next day. And it was repatriated with his personal effects to his family, thrown in a plastic bag in a closet, and a year and a half later, we came to learn through his brother that there was this device, and it was provided to the authorities because it might have some useful sound data on it, federal ATF people reconstructed that digital tape and gave us a pristine sound record of what was going on during these horrific last minutes from inside the club. And we synced it to the cameraman's footage, and that's why you heard it. So Matthew said, Joe, take a picture. Joseph Christina snapped this last still photograph from inside the club and made his escape, seriously burned, through one of the panels in the atrium window. What do we see here? We see a man, early 30s, cigarette in one hand, drink in the other, coat casually draped over his arm, looking out toward the center of the club as the smoke layer gets almost to his head. And it's almost like a Rorschach test, because you have to ask yourself, what's going through his mind here? Does he know that there is a band door 10 steps if he just wheels here and runs out? Is he looking out into the club at the mass of people stopped at the front door thinking, I can never get out that way? Is he looking for his girlfriend, Becky Shaw, who was lost from him there and who lost her life in the fire? Does he know that this stuff coming down is knockout stuff? It's not like the movies. 2 lungfuls of this stuff, you can't open your eyes, you're knocked down, you can't breathe. Okay? Does he know that? Well, we know some of the answers to those questions, because this young man, 32 years old, is named Jeffrey Rader. And he knew that there was a door there because he was a roadie. And he loaded people in and out. And I show this to people because he, before he lost his life in the fire, both he and Becky, like most people, do not appreciate how fast fire can go from an object of fascination to the instrument of our deaths. Okay? Had he only wheeled and run out, and we know by reconstruction that he had enough seconds to do it because we've synced it with the video and we've seen other people get out of that band door after Matthew said, Joe, take a picture. So I show it to audiences and college audiences to suggest that when you go to something, you must be your own best fire marshal. Okay? You've got to look at the exits. You've got to determine whether this place is a place for you. Okay? And I show it to fire service audiences to make the point that you have an amazing job. It's an amazingly important job, and it's an amazingly difficult job. I don't have to tell you about the political and economic pressures that there are in doing code enforcement. But I can tell you, I've talked to so many fire professionals, and so many of them knew they wanted to be in the fire service from the time they were 14 years old. I have not talked to one person who said, you know, when I was 14, what I really wanted to do was code enforcement. Not a one of them. They wanted to put the wet stuff on the red stuff. They wanted to save people, which is fine and good. Okay? But where the real bang for the buck is in code enforcement. Okay? And there were so many ways here that this could have been prevented. It's a funny job you guys have, and women have, who are in code enforcement. Because if you do your job really, really well, and you prevent the next Station Nightclub fire, you will never know it. And if you don't do your job well, and the next station fire happens on your watch, you will never be able to forget it. So I just ask you to take that back to you, to your communities. I salute you. I wish you good luck and Godspeed in the important work that you do. And thank you for your attention tonight. I'll take questions with this.
I want to thank all of you, and obviously I want to thank John. This has just been remarkable and very moving. Before we take questions, I have an announcement that I forgot to make at the outset, and that is, I'm very pleased to announce the state of Connecticut has approved and certified this program for 1.5 hours of training credit. All fire personnel please see Fire Marshal Tim Thoreau after the presentation to get your credit. And I believe Tim is here somewhere. Yes, and he has a thing to sign. So, having said that, are there questions? We can come up here so you can be seen by the masses. I will wander around. Any questions, thoughts, comments? Oh, here we go. Please stand, and we will talk right into that.
Okay, can you hear me?
Yes.
I just wanted to thank you because my best friend was in that fire,
I am very sorry.
and this is closure for me. I'll process it, but thank you. Thank you.
Any other questions? Yes, we have a couple. Please stand too.
The foam that was on the walls, is that a petroleum product?
Yes, it is.
I just want to say anybody with any firefighting experience would quickly point out that it's never the flame or the heat that gets you. It's that black stuff that we saw rolling out in 90 seconds. I was amazed, with some firefighting background, at how quickly that was rolling out the front door.
You know, when we see movies like Backdraft and Chicago Fire and stuff, they're atomizing ethylene glycol, and it makes this nice white smoke that doesn't hurt anybody. Structure fires aren't like that. I mean, once you reach flashover or flame over, and you get that radiant level layer that covers your entire ceiling, and that smoke layer drops. I'll tell you a story from the station fire. Many of the people, in fact, everybody that got out, made the same comment. They said, at a certain point, you know, all the lights went out. All the lights didn't go out. When the smoke layer got to about a foot below the ceiling, it was so perfectly opaque that none of the lights could penetrate through it. So their perception was all the lights went out. That's another factor in how hard it is to make your escape. And another reason why modern life safety codes are specifying that the type of exit sign that you see up there, you'll now see in modern hotels, are down around knee level. Because that's the only place you're going to see it if there's a ceiling smoke layer.
We have a couple other questions. Here we go.
How is it that the Durdarians and the manager got such little time? I mean, I know it was manslaughter, and you can pretty much kill somebody with a vehicle or whatever and get away with murder, pretty much. But I remember when this happened, they had a press conference the next day or whatever, and the Durdarians were sitting at a table sobbing on television. I remember that. And I just can't believe it.
Well, you asked a question that was asked by many, many people in Rhode Island and the area. And the answer, as best could be given, was furnished by the Superior Court judge that sat on the criminal cases. And what he tried to explain, and did a good job of it, was that punishment in the criminal law has to turn on degree of culpability. And degree of culpability turns on something that another fancy Latin name lawyers call mens rea, that is, bad intent. Well, as shocking as the ultimate result was here, he pointed out that no one ever intended that one person be hurt, let alone 100 people killed. So the criminal punishment has to turn not on this unexpected, horrific result, but on the degree of culpability of the individuals. And as shockingly careless as they may have been, they never intended any harm. Now, it's not a satisfactory answer to a lot of people. It's not viscerally satisfying when 100 people lose their lives, but it's the best legal explanation I think that could be given. Yes, sir.
Did you have the level of scientific expertise in fire and its destruction before this particular incident?
I did not.
So, because what impressed me the most was the science that you guys did in order to establish beyond a fact, second by second. So it must have been, who was the driver on the team to seek out and do the detective work to find the experts that led to the next expert to the next expert? Who was the quarterback?
A good question. This was not a class action. It was a combination of individual lawsuits. They were brought by, for the most part, 8 law firms that were part of what was appointed as a plaintiff steering committee that was appointed by the Superior Court presiding judge in Rhode Island. That plaintiff steering committee, consisting of representatives of 8 firms, met and worked on the case over a 7-year period, and we parceled out issues. We parceled out, okay, you firm, you be in charge of researching polyurethane foam, how it's made, its flammability, its toxic byproducts, how it was labeled, whether there are any consent decrees in the past about how it should be tested, how it should be labeled, that sort of thing. You firm, look at the beer manufacturer, look at the promoters. So we parceled out the responsibility. And one reason why I want to stress that is I don't want to suggest for a minute that I was the only lawyer working on this case. This case could not have been done by one lawyer or even one firm. And the answer to your question is each firm carved out its own area of expertise, and we engaged experts in many, many disciplines. Just so you know, by the time we got to a settlement, global settlement, which was by no means guaranteed, the plaintiff steering committee had advanced almost $1 million in out-of-pocket expenses on experts on discovery. So when you think, gee, you plaintiffs' lawyers, you got it made, it's like falling off a log. Not only were we out that kind of money with no guarantee of return, but if we missed a viable defendant in the 3-year statute of limitations period, and it's one reason why we were scrambling so hard about the polyethylene foam, if we did not file suit against a viable defendant and the statute of limitations expired, and then we came to learn who sold it, who made it, etc., all of the firms combined legal malpractice insurance would not be enough to insulate us from personal liability and personal ruin. So for 7 years, we all, and I personally, practiced with an albatross around our necks. And the weight that I felt lifted from me at the end of that 7-year period was palpable.
Here's another one.
What do you think was the turning point for the case? Was it the photo of the band that showed the foam in the background? Was it the tape recorder a year and a half later? Was it?
I think it was different for each defendant group. As you mentioned, the foam on the walls and some of the photographs we were able to find for pre-fire were instrumental in establishing liability of the town and LaRoque, the fire inspector. The tape might have been an important for something else. The videotape was very important for liability of the cameraman and his employer for delaying egress. So there were different turning points with each defendant. I will tell you this, we had to change the entire law of what's called joint tortfeasor contribution in Rhode Island in order to get even one settlement. If I can take 1 minute, this is kind of inside baseball, but it's important and it shows the lengths to which we had to go. I mentioned before that joint and several liability, you can sue more than one person, okay? If you want to settle with one and go to trial against the others, the law provides in most states that if you get, say, $1 million from this defendant and you go to trial against the remaining ones, your verdict against the others has subtracted from it the $1 million you got from the first settling guy. It's simple, it's predictable. Rhode Island has an antiquated version of that law that says the set-off will be either what the first guy paid or his proportionate share of fault, whichever is larger, determined after a trial. Which means that if we took the $1 million from the band, from their insurance policy, and a jury later found they were 95% responsible, and the verdict against the remaining defendants was $500 million, the set-off would not be $1 million. It would be 95% of $500 million. So for limited purpose, we were able to get the General Assembly of Rhode Island to change that law of joint tortfeasor contribution so that the set-off would be dollar for dollar, which enabled us, with predictability to take the $1 million from the band, to take the $1 million from the club owner's policy, and go forward knowing that whatever we got from the others, we'd just have the $1 million set off that we actually got. Okay? That change in the law didn't want anyone to be left last at the party. Okay? So it was instrumental in getting the ball rolling. So in a long-winded answer to your question, that was a major development that kind of turned the case.
All right.
That change in the law is fascinating. I'm also wondering, are there other changes in the law that came about as a result of this that you would point out?
Absolutely. Rhode Island, I mentioned that this was not a sprinklered building because it was grandfathered in. Rhode Island, in the wake of this fire, changed the fire code in many respects, but the most important respect was that buildings could no longer be grandfathered in if they had an occupancy above, and they lowered the amount, say 300. Now, it required people to sprinkler buildings that were not sprinklered before. And there was a hue and cry by some businessmen. And lo and behold, some 4 or 5 years after the fire, the law was tweaked again to raise the grandfathering threshold. So they eased up on it. We have very short memories. You know, the shock and awe fades. That's why it's important for museums like this and for presenters to keep it in the front of our minds. Yes, sir.
Last question, I think.
I'm very curious how you or whoever in the team had to deal with the trauma of listening to that tape and watching the videos over and over to identify details and things like that. How are you able to deal with that? Is this something that you had to, address with the specific people who were responsible for that?
As you might guess, we watched the Brian Butler video more times than I can count and broke it down second by second. The Matthew Pickett audio tape of the descent of the club into hell from the inside was only listened to by a few people. We, with the permission of Matthew Pickett's family, we were able to use it in the civil litigation to show certain defendant groups what a jury would hear. Okay? I promised the family that it would never get out. It would never get on the internet. Believe me, with the publication of the book, there are certain disaster ghouls, and they write to me and say, I've been able to find all these video clips, but I can't find the Pickett audio tape. It's not going to get out. It is so upsetting that it's everything you can imagine if you want to listen to a building full of people locked in who are being burned alive. Okay? That's all I can say. I listened to it for the first time through earphones, and my late wife watched me, and by the time I was done, I was a mucousy, teary mess. I was physically ill, and I went and got sick. Okay? It is that powerful. So it was wrenching for those few people that had to listen to it, but we were able to make productive use of it in advancing settlements with some of the defendant groups.
I misspoke. We have one last question, and then I'm sorry, but we just have to keep moving. We could be here all night.
So the Fire Marshal LaRoque, personally, what was he responsible for? And obviously, I'm assuming he doesn't have his job anymore.
Well, thank you. I will tell you that nothing personally happened to him, okay? There was a settlement by his employer, the town, and his master, the state. It didn't cost him anything out of his pocket. He remained fire marshal for another couple years and then returned to line duty at the battalion chief level. He retired on a disability, and he now lives in Florida. I don't know what that claim to disability was. I can only imagine the potential for psychological trauma, knowing that what was done and what was not done here. So legally and financially, nothing happened to him personally, but I wouldn't want to live in his head.
All right.
Thank you all so much.
Yes, I want to thank you all. Thank you. Well, this is obviously a sobering presentation, but it's also a remarkable insight into how great lawyering happens. I want to thank all of the fire personnel, emergency services that are here tonight. I want to thank the entire audience. I want to reiterate, Killer Show, we have signed copies out here. It is a remarkable book. I encourage you to grab one while you can. Thank you very much for coming. We hope to continue this series next year, and happy holidays to all of you. Thank you.